Good morning. Happy Thanksgiving Eve. We're here with Charlie O'Hara. He's back in studio, normally to answer some legal questions. Today, we're actually not taking any questions, I think partially because the situation at Ferguson is on everybody's mind. And I think, gauging from your perspective, maybe being able to shed some light on the process up to this point, sort of to inform the public kind of what went on behind the scenes. Something that you and Scott and I were discussing beforehand is maybe a lot of people's dissatisfaction with that this trial was not public. Can you sort of explain what the process is of a grand jury and how that begins and how it ends?
Well, it's actually not a trial. It's a determinate. What happens in the United States is when people are held in custody or charged with a crime or going to be charged with a crime, the government, whether it be the state or the federal government, has to have probable cause. And what probable cause means, there's a bunch of ways to say it, but that a crime was probably committed and that the person probably did it, whatever that really means. And it basically kind of means, is there some valid evidence that the person did it, enough evidence to go to trial and argue about? And what we usually do, at least in state court here in Kansas, and I think even in Missouri, what they usually do is they charge someone by way of an affidavit, and then the probable cause hearing, which would be like the grand jury, is actually in front of a judge.
Okay.
And so it's open to the public. Everybody hears what's said. The judge makes the ruling. It doesn't mean you're going to get convicted. It just means you're going to have a trial.
And that's separate as well from a preliminary hearing.
The preliminary hearing is just a hearing to determine if there's enough evidence to go to trial.
Okay.
Because after the preliminary hearing is the first time you plead guilty or not guilty.
Okay.
And most people don't understand that. So it's a preliminary mechanism to determine whether or not you even ought to plead guilty or not guilty, enough to charge you. Well, you can also, and federal court almost always does this, even here in Wichita and in Kansas, but you can also have a preliminary hearing, which is you can have a grand jury hearing, and that's secret.
Okay.
And why it's secret is because if people aren't charged, they don't want everyone to know the details. That's the theory of it.
Okay.
So like if there's a grand jury here in Wichita, which there have been, and I've attended, I can't go in as the attorney for the defendant. I have to sit outside, and if my client is at the grand jury and wants to ask me some questions, my client has to come outside and talk to me.
Okay. So
I can't even go in there. So it's not really an adversary proceeding. It's where the prosecutor or the state or the federal government presents the evidence that they think show whether there's enough evidence to show the person should go to trial. That's all it is.
Okay.
And so we could do it here in Wichita. We usually don't, and I think they don't do it in Missouri. But what I think the prosecutor here did, it looks like, is he decided rather than have the preliminary hearing, he was going to go to the grand jury. It would be secret, basically, although he later released all the evidence.
Yes.
But what actually happened in there would be secret, even from the defense attorneys, and he would let the people on the grand jury vote as to whether or not there was enough to charge the police officer, and that's what happened. And so everybody kind of is going, the system obviously can go either way at that stage, and a lot of people may have preferred one way over the other. We really have no control. That's up to the that's up to the prosecutor, and that's what he decided to do.
Okay, Charlie, thanks for shedding some light on that. We appreciate it. We are out of time. Went fast, but we're going to take a break right here. Back in just a couple of minutes. Stay tuned.